So I will introduce our speaker. Darlene Johnston is a member of the Chippewas of Nawash First Nation in Ontario. She earned a BA from Queen's University and a Bachelor of Law and Masters of Law from the University of Toronto. From 1993 to 2001, she was the research coordinator for the SON litigation team. From 2001 to 2009, she was an assistant professor at the University of Toronto Faculty of Law. From 2009 to 2001, she was an associate professor at the Allard School of Law at the University of British Columbia. She was also the academic director of the Indigenous Legal Studies program at the law faculty. Upon her retirement from UBC, she returned to her First Nation at Niashingming, where she serves on the United Nations Declaration on the Rights of Indigenous Peoples Implementation Working Group. We're so happy to have her as part of the group. I am currently working with Shared Value Solutions, supporting the group as well. Please take it away, Darlene. Yay.
Miigwech. Ani, Bobujo, Nakwegi, Jugokwe, Indigenous, Wabijeshi, Nindodem, Neashingming Donjaba. I just, my limited Nishna Bemoen, my Anishinaabe name is Noonday Woman, and I belong to the Martin clan. Thank you all for being here. I'm very excited to be part of this process. Jessica posted in the newsletter several months ago that this committee or working group was going to be formed and asked for applications and blurbs from each of the applicants about what we thought we could contribute to the working group. And those applications went to Chief and Council, and Chief and Council appointed the working group. So I'm very happy. Since I've been home, I've been looking for opportunities to contribute to community work. And so I appreciate the appointment by Chief and Council. There are other members of the working group. We have Alex Duncan, who is doing a PhD in fisheries at the University of British Columbia. Miriam Johnston, who has a great deal of experience in dealing with governments, particularly on behalf of First Nations, particularly the Ontario government. Paul Jones, who is a longtime counselor, although he's at the moment elder on the advisory committee to the Nuclear Waste Management Organization, I think. That's what the acronym stands for. And Mark Najwan, also a community member, living now on the peninsula, and he's an artist, but he also has experience working with the federal government on Indigenous issues. And I think I can speak for the working group to say that we're all really concerned and excited about the process that we're engaging upon. So I need to go through some very technical material. It involves legislation and federal legislation, that is, and international law. And I apologize in advance for the technicality, but I think it is important to be precise because these are legal matters. Now, as we go along, I'll try to give some context, and I'll try to use plain language. Legislation, lawmakers do not use plain language. And I will try, as I said, to use plain language, and I'm really hopeful if people have any questions, just to interrupt me at any time by either raising your hand or going into the chat, and I'll be happy to deal with the questions that you have. It's a rather long PowerPoint. I think it's 34 slides, but I'm confident we'll get through it within the hour and then have at least half an hour for questions and answers. And for the working group members who are joining us tonight, they will also be available to contribute, and it would be good for you, I think. You may know them by name, but also to see their faces. I should also indicate that although I'm trained as a lawyer, I'm not currently practicing, and that I'm not giving legal advice. I'm just trying to give some explanations of some very complicated very complicated material, but also very, very important material. So I'm going to start the PowerPoint now, and I'm hoping it will shift. No, it's not. Jess, do you know how I moved it to the next slide? I used to do this all the time as a professor.
Maybe if you if you have an arrow to press it to the right.
Oh, yes. Thank you very much.
There we go.
Okay. So there was a picture there. I'm not sure what happened to it. It was a picture of Adolf Hitler. And it's important to understand that the United Nations were created at the end of World War II because there had been such atrocities committed by the Nazi regime, including the Holocaust committed against European Jews, as well as the treatment of prisoners of war. And they also had a elimination campaign against LGBTQ plus people, as well as people of different races, not simply Jews, were killed in mass by the Nazis. And so there was hope after Germany surrendered in 1945 that the victorious nations, including England, the United States, and Russia, could secure peace, world peace, going into the future. And so the United Nations was formed, and I note here that it was a successor to the League of Nations. Now, the League of Nations is also a body that was created after World War I and the Treaty of Vienna in 1919. The League was created in 2020, in 1920. And it had similar objectives, primarily to achieve disarmament after World War I, and then to secure world peace through the protection of human rights. And in both cases, only parties, nation states that recognized each other as states were eligible for admission. So there's a famous Cayuga chief from Six Nations who in the 1920s wanted for the Six Nations to become a member of the League of Nations. And his name was Descahe, and his English name was Levi General. And he actually was able, with support from non-Indigenous people, to travel to Geneva to the League of Nations. And he actually traveled on a Haudenosaunee passport, which was the first instance of that. Unfortunately, the United Nations would not hear him, the League of Nations. And that was primarily because England and Canada at the time were trying to dispose of the hereditary councils, chiefs and councils, and had taken the wampum from their council house and locked the council house doors and imposed a elected council under the Indian Act. And the Six Nations, obviously, and other First Nations felt that this was a violation of their international rights. And that's why Descahe did go to Geneva. I think it was maybe 1924 or 1925. And then, but what he realized and what First Nations realized when he was not permitted to address the League of Nations was just how colonial and discriminatory the international law system was. And that goes back to its roots in terms of European international law. The first book on international law was written by a Dutch man named Grotius, and it was what he called the law of war. And basically, this was in the 1600s. He argued that it was a just war, that is, that it wouldn't break international law, if the European states made war on Indigenous peoples in the Americas. And the reason he said that was a just war is because the Indigenous peoples were considered pagans because they weren't Christians. That's in the European point of view. And so unless and until Indigenous nations became Christians through the efforts of missionaries, they had no rights under law. They had no property under international law, and therefore they could be the subject of aggression and, in a number of cases, elimination. So it's important, I think, to remember that international law was deeply colonial. It wasn't just racist, but it was intended to dispossess Indigenous peoples in the Americas. And a century later, the Swiss thinker Vital published a book known as The Law of Nations, and he's considered the father of international law. And again, he said it was international law that so-called civilized Christian nations could attack and steal land from Indigenous peoples in the Americas without any legal consequences. And so basically, international law has facilitated the dispossession and elimination of Indigenous peoples worldwide. And it's sad to say that in 2023, international law is still deeply racist and colonial. And we'll see some of that as we go through the PowerPoint slides. Now, again, I had some nice pictures in here. I don't know why they didn't come through, but to talk about the structure of the United Nations, it's quite a complicated organization. There are a number of different bodies that have different responsibilities. And so basically, the first thing to notice is that it consists only of states parties. That is, you have to be recognized as a nation state in the international law meaning of the word, of the term, in order to be part of the General Assembly. In the General Assembly, every state has one representative and one vote. And currently there are 193 members of the General Assembly, but there are no Indigenous members recognized as states. The one exception is that Palestine has a limited participation. It's known as an observer, and also Vatican City, for reasons I don't understand, I could probably guess, also has observer status. Then there's the Security Council, which next to the General Assembly is a very powerful body. There are permanent members of the Security Council and then elected members. The states that have permanent membership are Russia, the United Kingdom, and the United States. And whenever there's a conflict, which people argue is in breach of international law, such as the war in Ukraine, or what the Israeli state is doing against Palestinians, there can be resolutions made by the Security Council, but Russia has blocked any criticism of its war in Ukraine, and Israel has been able, with the backing of Russia, to also avoid any scrutiny or consequences for what it's doing in Palestine. There's also an Economic and Social Council, which does a lot of policy and research work for economic and social rights. There's a trusteeship council for countries where the people have not yet achieved self-determination, where they're under some other state's control. And then there's a secretariat, which manages all the meetings and publications of the United Nations. So the General Assembly is sort of the top organ of the United Nations. And again, I mentioned it's one state member. It has far-reaching powers, more powers than any other international organization. It is able to make international law and to interpret international law. Sorry, I just realized I missed one other body of the United Nations, the International Court of Justice. And like the rest of the United Nations system, Indigenous peoples are not recognized as states, and so they can't bring any claims to the International Court of Justice for matters such as breach of treaties. And both Canadian law and international law do not recognize our treaties as being international treaties, unfortunately, but perhaps predictably. So those are the main bodies that constitute the United Nations. Now, in terms of the lawmaking power that the General Assembly has, they can create treaties for states to sign. They can create conventions and also declarations. And declarations are the lowest form of international law that can be made by the General Assembly. And we'll be looking in particular at the United Nations Declaration on the Rights of Indigenous Peoples, which was passed in 2009. I'm watching the chat again. If anyone has questions or just wants me to slow down a little bit, I have a tendency to speak very quickly. So when the United Nations was formed, it was done by a document known as the UN Charter in 1945. It has some very important provisions, including the right to self-determination. But under international law, this right, until UNDRIP, has been denied to Indigenous peoples. And it's been denied to them through a theory called the Blue Water Thesis, which I'll mention briefly. And Indigenous peoples are referred to as indigenous populations in international law until UNDRIP. And that was very deliberate because peoples have the right to self-determination, but international law declared that indigenous populations did not have the right to self-determination. So under the United Nations Charter, which was formed in 1945 at a convention in San Francisco, it's a very lengthy document. Excuse me, I need a sip of water. And most international legal instruments and federal and provincial legislation begin what they call with a preamble, and it means it's before the actual law. So the preamble can help interpret a law, but it's actually not legally binding. So you can't go and say, oh, the preamble says this, because the reply from an international law lawyer would be, well, the preamble doesn't bind a state. In any event, the preamble tells what the United Nations was established for, and it was basically to reaffirm faith in fundamental human rights. Again, this was after the Nazi atrocities. There were other atrocities and genocides committed during the World War II, one being the Turkish state committed genocide against the Armenian people. That genocide has not been formally recognized by Turkey, although the Holocaust has been recognized by Germany and other states as being a violation of international law. But the United Nations then was to establish or to reaffirm the dignity and worth of the human person in the equal rights of men and women and nations large and small. And here I've highlighted in red because our nations, although we're small, we're still nations, but that was not accepted in 1945. It was not accepted really until 2009. Now, the first part, laws are divided up into chapters, which are basically sections, and then they're divided up into articles, or sometimes they're referred to as clauses or sections. So in Article 1 of the UN Charter, the purpose again is to maintain international peace and security. And so they want to take collective measures, that's all the members of the UN, for the prevention and removal of threats to the peace, suppression of acts of aggression, other breaches of the peace, and to bring about by peaceful means and in conformity with the principles of justice and international law, adjustment or settlement of international disputes or situations which might lead to a breach of the peace. And one of the ways this was to be accomplished was by establishing the International Court of Justice, where states could basically sue each other and the court would issue an opinion. The other way was primarily through the Security Council to take action whenever there was a breach of peace. Now, it was recognized as crucial to the purposes of the UN Charter or the United Nations that in order to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples. Again, I've put this in red font because this is crucial. This is the very beginning of the UN Charter and the formation of the United Nations, and they're saying they're there to protect self-determination of peoples. And that's, again, why our peoples were referred to as indigenous populations and not peoples. Now, the membership, again, is open to peace-loving states. And I've highlighted state in both of these articles because you're probably getting used to this idea now. Indigenous peoples were not considered states, and so they could not be members, and we still can't be members of the United Nations. And we still can't go to the the International Court of Justice. Our only recourse, if we think there's been a breach of international law, is to go to the Human Rights Committee of the United Nations. And there's been some success there by the Cree in Northern Quebec and by Indigenous women in terms of the loss of status before Bill C-31. Now, the reason self-determination was denied to Indigenous peoples is because somebody came up with the idea that of the Blue Water Thesis. So basically, the United Nations was meant to decolonize, that is to get rid of colonial powers and grant independence to former colonial peoples. But Belgium was the promoter of the right of self-determination because they had already given up all their colonial possessions in Africa. But the United Nations, the United States did not accept this position because that would mean there would be independence for tribes in the United States. And so the United States instead said that in order to be eligible for decolonization, the presence of the blue water between the colony and the colonizing country, or at minimum a geographically discrete set of boundaries, was needed. And what this really came down to is Canada is the successor to Great Britain. Canada's still a colonial state, but because we're not separated from Canada by the ocean, or because we don't have our, they don't recognize our boundaries as being separate from Canada, we, by this theory, the Blue Water Thesis, Indigenous peoples worldwide are not allowed to gain self-determination. And again, I've made this point several times, that if you're not considered a people under international law, then you don't have the right to self-determination. And there were some early United Nations instruments that did talk about Indigenous peoples, but Canada, not surprisingly, United States, Australia, and New Zealand refused to use the term because they did not want to see self-determination. Now, it's important to understand, as excited and hopeful as we are about UNDRIP, that there are different levels of international law, and some types of international law are considered more authoritative. That is, that they're binding on states. States will suffer some, ideally, consequences if they break those laws. But what the international community has decided, without the participation of Indigenous peoples, is that when they ratify a treaty or conventions, which are actually very similar, they're legally binding. The state has to obey the law that they've signed on to. They're not forced to sign on to a treaty or a convention. A treaty is usually between two or more states parties, whereas a convention is open for any state in the United Nations to ratify. And the term soft law indicates, I think, that it's a much weaker kind of law. And so UN declarations, including UNDRIP, are not legally binding. They may incorporate existing legal obligations, and they so if there's customary international law to protect Indigenous rights, the declaration can reinforce that. It can lead to the development of new international law as states' courts begin to apply the declaration, and they can affect the conduct of international relations by states. But it's very typical for colonial states to say declarations are not law. And that's what the Harper government did in 2009, when together with the US, Australia, and New Zealand, they voted against the declaration. Now, in following the charter, there was the UN Declaration of Human Rights. And I'm actually going to skip through the preamble because I think I need to move a little bit faster. But the declaration, again, spoke about the right to self-determination, but in such a way that it didn't apply to Indigenous peoples. So if we want to look at UNDRIP's development, we have to start with the Working Group on Indigenous Populations, and you know what that means now, why I have it in red font. was created by the Economic and Social Council. People call it ECOSOC. That happened in 1982. And it was because there was a study by Martinez Cobo on discrimination. And there was an international convention against discrimination. So the UN was willing to look into this, but I think they were surprised and very concerned, especially colonial states, that this study actually opened the door for the recognition of international rights of Indigenous peoples. And in fact, they were right to be worried. So they started the first draft of the declaration in 1994. And then they completed, the first draft. And then it was sent to the Commission on Human Rights, and then to approve the proposed declaration before it went, the commission would approve the declaration, then it would go to ECOSOC, and then to the General Assembly. Now, partway through, actually quite late in the efforts to develop UNDRIP, there was a UN Permanent Forum of Indigenous Peoples, the UNPFII is the acronym, and it's a high-level advisory body to ECOSOC. It was established in 2000 in order to deal with Indigenous issues related to economic and social development, culture, the environment, education, health, and human rights. And it was to promote respect for and full applications of the Declaration of the Rights of Indigenous Peoples, and to follow up the effectiveness of this declaration. Now, the Permanent Forum has 16 members, 8 are appointed by governments and election by council, and 8 are appointed by the president of the council, that is the ECOSOC Council, on the basis of broad consultation with Indigenous organizations. So there's a bit of unevenness there, actually quite a lot. The governments get to pick their representatives, but organizations, Indigenous organizations, can only apply, well, they don't even apply, but they can only petition basically the president of ECOSOC to appoint certain organizations. But still, this forum started meeting in 2000. It meets every spring in New York, and it played a very important role because here Indigenous peoples could go appear before the Permanent Forum and make their case both for their rights and the violation of their rights. So this was the first time in the history of international law that there was a place for Indigenous peoples to actually be heard. They had no power or authority, but they could at least speak for themselves. So UNDRIP, after more than 20 years, almost 30 years, was adopted by the General Assembly in September of 2007. So that's 26 years ago now, but we still think of it as being very new. I think because there's been so little achieved so far under UNDRIP. There was very strong support in favor. There were 4 colonial states who voted against the declaration's passage. And again, not surprisingly, Australia, Canada, New Zealand, and the US. There were a number of abstentions, that is, people who didn't vote. And some of them, like Bangladesh and Kenya, Nigeria, Russia, Samoa, and Ukraine, they abstained because they argued, and China as well, but I don't think, doesn't say that they were that they abstained. But they basically said, we have no Indigenous peoples. They denied that there were any Indigenous peoples, that there had ever been any colonization within their state, except for British colonization. And so they refused to sign it. But there was, you can see, 144-4 is a pretty resounding victory. And then it took by 2010, so it's in hindsight only 3 years, for Australia, New Zealand, Canada and the US to adopt the UNDRIP. But Canada, under the Harper government, initially refused to recognize UNDRIP, and then it made a statement of support in 2010, but it was very limited. And so you see in the bolded font, they said it's an aspirational document. That is, it's what we hope sometime in the future to achieve, but there was no, they could not be compelled to achieve those rights. And so they said it's non-legally binding, does not reflect customary international law or change Canadian laws. So they basically said it has no power over the Canadian state. When Trudeau was running to be Prime Minister in 2015, he made a promise to Indigenous peoples in Canada that if he was elected, they would accept the UN Declaration. And so in 2016, the Minister of Indigenous Affairs, Carolyn Bennett, announced that Canada is now a full supporter without qualification of UNDRIP. And then so that they said they would start working towards the achievement of UNDRIP. Now, the Permanent Forum was very pleased with this progress, welcoming the endorsement of Canada for UNDRIP, and said they looked forward to its immediate implementation. So there was a responsibility since 2016, which Canada accepted, it had never accepted before, to implement UNDRIP, that is to make it real on the ground that those rights were recognized and protected. And so because Harper in a way had international law on his side when he refused to accept the declaration, because international law instruments are not legally binding until the federal law has, it's called incorporation, it's a very technical term and process, but basically international law instruments don't apply until Canada passes a law that says, yes, they do apply. And so there was in 2016 a bill introduced by Romeo Saginaw into the House of Commons, which would have implemented the declaration. It was passed, I think, quite remarkably, again, due to Saginaw's leadership. He is a Cree from Northern Quebec. But to make law in Canada, first it has to go to the House of Commons, which is part of Parliament, and then it has to go to the Senate. And both the House of Commons and the Senate have to pass the law. But the Conservatives were strongly opposed to Saginaw's bill. And when they basically filibustered, that is, they kept drawing out all the debates, and they kept pushing off the experts that wanted to speak. And finally, a new election was called by Trudeau. And the technical term is that Parliament is prorogued. And so basically, it died in the Senate. That is, the expression is it died on the order paper, which was very, very disappointing for the First Nations. Not all First Nations supported implementation. Some First Nations and Indigenous critics say it actually waters down international rights of Indigenous peoples, but the vast majority of organizations and First Nations were bitterly disappointed when the Conservative senators basically blocked the bill. Now, Trudeau again promised during that election that if they were reelected, the Liberals would reintroduce the bill, and they kept their word. It took them a little while, almost to the end of the next Parliament, to pass the United Nations declarations on the rights of Indigenous peoples. So this is what we're really here tonight about, is they've passed this law, and there's a role for consultation of Aboriginal peoples or Indigenous peoples in Canada before they develop an action plan, which the law requires. They have 2 years to develop an action plan. And it was passed, the law was passed in 2021 in June, so they have to have their action plan ready for this June, which is a very tight turnaround period. And we've already, Chief and Counsel have already prepared a letter to go to Minister Lametti, who's the Minister of Justice, who's in charge of this law, to say this isn't enough time. This is a violation of UNDRIP to make us decide in such a short period of time. It's also a violation of our constitutional rights to be consulted, because this is totally inadequate, way too rushed, not enough resources. So we have a lengthy preamble. I'm not going to read it, except the first one that says Canada recognizes UNDRIP, the rights in UNDRIP. Sorry, it said it should be, B-E, not just B, enshrined in the laws of Canada. And again, that's because the international declaration doesn't apply until Canada passes legislation, which says it applies. And so there's an interpretation section in the UNDRIP Act, which is important because the critics had argued, Indigenous critics had argued that this act would take away from the rights of Indigenous peoples under Section 35 of the Constitution. And so this Section 2 sub 2 is really what they call a non-derogation clause, so that you can't interpret this act to take away constitutional Indigenous rights. And also they were forced to clarify, this was amendments that were introduced by Indigenous leadership, that nothing be construed as delaying the application of the declaration. So the concern of Indigenous leadership was, well, they'll pass this act and then they'll say, oh, we're studying it, we can't do anything right away. The purposes were to affirm the declaration and to provide a framework for implementation. That is, Canada can pass the law, but it really doesn't have any impact until things change on the ground. That's what implementation is all about. And so an important part, this is a very short statute, one of the shortest I've ever read, one of the shortest Canada has ever passed. It's only less than 10 sections. But it argued that it states in consultation, Canada has to develop, has to take all measures necessary to ensure the laws of Canada are consistent with the declaration. In other words, we'll look in a minute at the types of rights that are recognized by UNDRIP, and that Canada had to, if any of its laws were contrary to UNDRIP, it would have to change those laws. So that's a very big deal for the government and for Indigenous people. So
Darlene,
it was required. Yes.
I was wondering if this is Paul Jones
Yes.
asking the question. I was wondering if anybody has challenged that, or is it too early to challenge anything, and the people that didn't vote for it, they could probably make a court case and challenge it and set it back a few years at the same time.
Yes. So the AFN supported the legislation. Some Haudenosaunee nations opposed it. A commentator for the Caughnawaga Nation is Russ Diabo, and he was very vocal and published criticisms. And I think it would be possible to challenge this legislation as a violation of the rights in and of itself, both of UNDRIP rights and constitutional rights. But so far, to my knowledge, no one has undertaken to do that. If the action plan gets passed and Indigenous peoples are not happy with it because it was too quick and they didn't have enough time to participate, then I think as well, it would be quite straightforward, but this is not a legal opinion. I think somebody else could give you a legal opinion that you could challenge that, take it to court and have the law struck down. Thank you for the question. So the action plan, they only have 2 years to develop it, but it says in consultation at the top there, 6(1), the minister must, he has no choice, in consultation and cooperation with Indigenous peoples and other federal ministers. So you wonder what the Minister of Natural Resources might have to say about it, or the Minister of Justice, or the minister in charge of prisons and criminal law, and what they might say. But with consultation and cooperation, prepare and implement an action plan to achieve the objectives of the declaration. So there has to be, by June 23rd, an action plan to say, this is how we're going to make UNDRIP make a difference on the ground in Canada for Indigenous people. Again, this is the 2-year limit, and this is why we're under the gun, in a sense, because the Minister of Justice put it off and put it off and put it off for 1.5 years, and then finally made a move to provide limited resources, which is why it's so important that our community, our council decided to use cold water funds, because the federal government is only sponsoring or providing money, providing funding to the PTOs, that is the AFN, the Union of Ontario Indians, and other regional organizations. So the fact that we're even involved as a First Nation is because of the work that was done by band administrators and pursued by Chief and Council. The government is under an obligation to provide a report every year to Parliament in a way to hopefully keep pressure on the government to make progress. And so the Implementation Act, the first report that went to Parliament in June 2021, said there's collaborative work, 23.6 million in funding was made available. Now, it wasn't made available to our First Nation at all. Again, we had to rely on the cold water funds, and I think there's only one other First Nation, Pick River, who has managed to get fund. No, I'm incorrect. Jessica, clarify that.
We did get funds. We didn't get the amount. NAWASH didn't get the amount applied for, so an application to Coldwater was approved to help supplement those funds.
So using the federal dollars, the AFN and other regional organizations submitted 200, let me back up a bit. To get money, 208 applications were received, and 147 were approved. And again, this didn't happen until the early fall of 2022. So we get to December and people find out they have funding, and they have basically 3 months to participate in consultation. So let's look at what UNDRIP actually contains. And I think earlier I might have said it was passed in 2009, but it was 2007. And so again, the preamble, which is not legally binding, you can't sue a state because they don't follow the language of the preamble, was meant to recognize the rights and to implement them in consultation. And one of the most important articles, which sets the stage for almost the whole declaration, is that Indigenous peoples have the right to full enjoyment of fundamental freedoms, and that we're free and equal to all other peoples. We have the right to be free from any kind of discrimination. That's Article 2. Article 3 says, Indigenous peoples have the right to self-determination. This was the most hardly fought over clause or sentence in the whole declaration. And again, that's why Canada, US, Australia, and New Zealand refused initially to accept the declaration. Even the name UNDRIP refers to peoples. Canada resisted use of the term peoples until the bitter end. They wanted it to say Indigenous populations. And then Article 4 waters down Article 3 a little bit, because Article 3 just says straight out self-determination. And Article 4 says, well, the people can choose really to autonomy or self-government relating to their internal and local affairs. So that's basically saying, well, First Nations in Canada can control their own affairs, but they don't have any say in what happens off their reserves in their traditional territories. Sorry, I've lost my, here we go, arrow. Now, 18 and 19 are also very important, and that is we have the right to participate in decision-making in matters that would affect our rights through representatives that we choose through our own procedures and to develop our own decision-making institutions. And that under Article 19, states have to consult and cooperate in good faith. That's an important expression through their own. So they have to deal with us through our own representatives in order to obtain, this is, I think, second to self-determination, the most important phrase in the whole declaration. The states must obtain their free, prior, and informed consent before adopting and implementing legislative or administrative measures that may affect them. That's anything that may affect us, whether it's environment, resources, government, funding, child welfare, our own laws, our own police, our own education, just it's wide open. And this clause is called FPIC. The acronym is because it's free, prior, and informed consent, FPIC. So you hear a lot of people talking about FPIC under UNDRIP. And I hope now that you understand what that means, but that's absolutely central. Self-determination and FPIC is really the heart, because if there's no FPIC, if there's no self-determination, there's no FPIC, and if there's no FPIC, none of the other rights can be protected under UNDRIP. Under Article 32, we are determine and develop our own priorities to the use of our lands or territories or other resources. So this would give us power off the reserve. It's not self-government like a municipality. It's control over our territories. And Article 2 also, again, refers to FPIC. States shall consult and cooperate in good faith with the Indigenous peoples concerned. And I could argue here, that's not the AFN. That's the Chippewas of Nawash unceded First Nation. And that in order to obtain their free and informed consent prior to the approval of any project affecting their lands or territories and other resources, particularly if there's going to be exploitation or utilization of minerals, water, or other resources. So we can think about timber, we can think about oil, we can think in our territory about fish, environmental protection. The states have to consult with us. And again, that's one of our biggest complaints as a working group and for Chief and Council is how can they consult with us when they've given us 3 months and hardly any money to do this? We have a right to determine our own identity and membership and our own structures and to select membership of our institutions in accordance with our own procedures. Now, there's over 40 articles in UNDRIP. I've only highlighted a few because I think they're the most relevant to what we're doing here tonight and the most important parts of the agreement, of the declaration. Now, so far it sounds good, but the states, particularly the colonial states, pushed back. They would not pass the declaration, even though it had been approved at ECOSOC, unless they could protect their own sovereignty. And so Article 46 was the last provision that the states tabled at the very last minute. And they said to the indigenous peoples, unless you accept this, there's no deal. And so what does Article 46 do? It says that the declaration can't be interpreted as authorizing any action which would dismember or impair, totally or in part, the territorial integrity or political unity of sovereign and independent states. So with that expression, they're saying indigenous peoples are not sovereign or independent, that we're not states, and that anything we do cannot disrupt the territorial integrity. That is, we can't take our lands and our resources out of Canada. And we can't really disrupt the political unity and say, like Quebec has in the past, oh, we want to secede, we want to be our own states. And there's also the possibility for the states to use their own laws to harm indigenous peoples. It's built right into UNDRIP. So it says they'll be protected in Article 2, but they're subject only to such limitations as are determined by law and in accordance with international human rights obligations. Now, this actually is almost word for word what we have in the Constitution, which basically says constitutional rights are not absolute. The state can interfere with them as long as they can justify them. And our experience with Aboriginal rights is it's very hard for First Nations to establish them and very easy for the governments, Canada or the provinces, to limit them. So this is a dangerous clause when it comes to protecting Indigenous rights. Okay, so again, I'm hoping we'll have lots of time for questions and answers, and that you'll hear from the members of the working group. As I said, the group was appointed by Chief and Council in December. We have some funding from Justice and Coldwater Trust. The project is being facilitated by Project Director Jessica Martin-Kijik of Shared Value Solutions. And our members are Alex Duncan, Miriam Johnston, Darlene Johnston, Paul Jones, and Mark Nadjawan. Okay, so the draft action plan, without us even having seen it, has already been released in December. It's already out there. And people like organizations like the Union of Ontario Indians have already given their input and submitted a report to the Minister of Justice, David Lametti. So they're way ahead of the game. They've been favored in this process by timing and money, funding. And I asked, I saw in the Anishinaabeg newsletter that they had completed and submitted their report. I wrote to them the first week of January saying, we're doing this work, can we see your report? And they didn't even reply to my email. So I think it's going to be very hard to get cooperation with the PTOs, again, AFN and the regional organizations who got the most money, got the money early, and got the draft early. And if we don't know what they're saying, how can we know if their official input is going to protect us or actually hurt us? So one thing Chief and Council might consider is writing again to Minister Lametti and saying, we need to see what other organizations are saying because they don't represent us and they've had an unfair advantage in this process. So the plan is out there. At least the union, maybe the AFN would let us know because we are members, what they're doing. I don't know what kind of consultation they had, but because we are members, we should have been consulted. We have to get our work done here by March 31st. And today's January 17th, And we've moved as quickly as we possibly could have since we got the funding confirmed in mid-December. We hit the ground running in the last month, even with the Christmas break. So we have to get our feedback in, and which we want from the community. And then the feds are going to finalize the plan by June 30th. And they're going to send it to Parliament. And so again, this I think is a ridiculous time frame. We get basically 2.5 months now and counting to do our internal consultation. We've had no federal consultation, no regional Indigenous consultation. So we really do need community support to get this done. Now, the action plan will go to Parliament. There's no provision for any hearings at Parliament. They just have to file it with Parliament. Nobody's going to judge it unless we take them to court. We meaning Indigenous peoples, not necessarily Nawash, although sometimes we've had to do things on our own. Okay, so how we're going to work is that we have working group meetings. We've already had 2, I think, and then we'll have more. We're having one tomorrow night to debrief on what we've heard from you tonight. There's going to be more community meetings. We're going to develop questionnaires and do community interviews. We'll do a draft report for you and get your feedback and finalize it, and then we'll report to the minister. We'll see what they send back. Sometime after the end of March, we'll respond to them. And then going forward, we just have to be really vigilant to make sure that our interests are protected. Okay, so I think that was the last slide. And happy now for questions, comments.